So when thinking about a common law system and a civil law system, it is best for me to describe the main differences and how each of those are applied to better understand it. So in England and Wales, for example, we have both civil law and common law. And not to forget about the criminal law, because there is an overlap with that as well. But for the purposes of this video, to explain the differences and similarities and how they're applied, I'm going to compare and contrast the common law and civil law so that it might be better to understand. So the best way to think about civil law is that this is a codified body of law which is written down in acts of parliament which are passed and enacted as written, solid, codified law. And just to explain a little bit more about what that means, for example, there might be what we call a bill, which is draft legislation, draft law, that is introduced to Parliament, and the Westminster Parliament being the supreme lawmaking body in the United Kingdom. This bill, this draft law, will go through various stages of debate and discussion, and it might propose brand new law for something that has never been considered before, or it might seek to solidify and consolidate previous law and previous decisions, which is important, and I'll come back to it, into a new statute, a new piece of law which is a singular piece of legislation that lawyers and individuals can refer to, and of course the courts can refer to when deciding cases that come to court on any given set of facts. Taking one or two examples, one of the oldest, the Offences Against the Person Act of 1861, set out various offences against the person, such as assault. For example, you might know a Section 47 assault. This comes from the Offences Against the Person Act of 1861, Section 47, assault occasioning actual bodily harm. You may also have heard of Section 18, wounding, and Section 20, wounding. The difference between the two being intention, Section 18 being the one with intent. Again, both of these coming from the Offences Against the Person Act of 1861. More recent examples include the Equality Act of 2010, which sets out various things such as discrimination and protected characteristics, and so on. More recent still, the Consumer Rights Act of 2015. This sets out, you guessed it, various rights of consumers when participating in a consumer transaction, solidifying and codifying the consumer's rights as opposed to freedoms, such as if there is a contract in place between a consumer and a trader, it provides various rights that are enshrined within the legislation. Ultimately, what this means is that the consumer has a right to those remedies set out in the Act. Parliament set about consolidating various bits of law, some of which came across from European law, some of which came through previous decisions in the English court system, and they were solidified into the Consumer Rights Act. This Act and all of the others essentially makes it easier when a case comes to court for the judge to say, well, this set of facts clearly represents this bit of law in this statute, so it's quite clear that this law was intended to apply to this set of facts in this particular way, and this is what's supposed to happen. So the first main difference is that civil law that you can think of as being codified in that sense. And the main sources of this law are obviously legislation, but there are also statutory instruments and other regulations and other kind of bylaws, which are other forms of written law that can be applied in the same way. Another important aspect, which is when we're going to move on to the contrast section with the common law, is as for civil law, judges' decisions are not necessarily binding on a given case, because if the statute or any other written legislation contradicts what the judge is trying to say, then ultimately the judge is bound to follow the legislation. But of course the judge will apply the legislation in the way that seems most appropriate. Some cases will be very much stricter than others and will be absolutely crystal clear in the legislation, and the judge will have no leeway whatsoever. And this, of course, is where we come on to the contrast, which is the common law. Common law is effectively a body of decisions made by judges when cases come to court. The representatives, or even the individuals themselves, will present the facts as they are to a judge in court, and the judge will seek to apply any relevant law to the facts in the particular case. Given that every case is very subtly different, but some of them are broadly the same in the principle, the judge will create what is called a precedent based on that type of case with those type of facts, given the interpretation and application of any given law. These decisions then form a body of hierarchical decisions and authorities which lower courts must follow. Starting with an obvious example, if the Supreme Court considers a case and makes a decision on a particular type of case, every court beneath the Supreme Court must apply the same decision and the same principles set down by the Supreme Court. Similarly with the Court of Appeal, any court below the Court of Appeal must apply any decision made in the Court of Appeal, and the same for the High Court, and so on. Some of you may have heard of the term test case. This usually refers to a new type of case or set of facts that comes before the court for the first time. Much like the Ring doorbell case that I summarized in yesterday's video, I've linked that below if you want to check that out as well. Using that as the example, that was one of the first times that a Ring doorbell and something of that nature came to court for the judge to decide whether or not the use of it amounted to harassment, breach of data protection, and other things. Whilst this was in the county court and its decisions are not necessarily binding on itself, it will be extremely persuasive for any new case that comes to court if the case facts are sufficiently similar to that was decided in that case. Taken together, all of those decisions form a body and collection of judicial decisions which ultimately are referred to as common law. As practitioners, we have various textbooks which are updated every year with new decisions, often overriding previous decisions, and even many tests that relate to criminal offences. For example, the test for dishonesty in criminal offences was changed when a new case came before the Court of Appeal. In this case, and the test of dishonesty, it was the case of Ivy and Genting Casinos that came before the Supreme Court, which essentially said that the original test, which was set out in a case called Gauche, had serious problems, and essentially had a dramatic impact on how that test would be applied moving forwards. So whilst that is not codified law that you can normally think of as a civil law system, it would certainly be a common law decision which can then be applied to all cases moving forwards. So how do the two of these work and apply together? Well, that I've just explained as the civil law system, which is a codified body of law, which is written down in statutes, statutory instruments, and regulations, will be applied to each case as they come to court, and the judiciary will make decisions based on the facts that come before them, deciding how different types of cases should be decided on any given set of facts when compared with the legislation. Using one example of the offence of the possession of a pointed or bladed article in a public place, the offence itself was fairly straightforward, set out in the legislation. Various cases have come before the courts to decide whether or not an instrument amounted to a pointed or bladed article for the purposes of the Act, and therefore whether or not the defendant was guilty of the offence charged. One such example was that of a butter knife. Now, a butter knife does not normally have a bladed edge in the conventional sense, in that they are not usually sharp. In this case, however, the court said it mattered not whether it was a sharp edge or not. The court said it would be inviting great mischief if it was to argue in case after case whether or not the edge was sharp. So many comments that I've had on videos have said that if it's not sharp, then it's not a knife. But of course that is not true, because common law decisions have said so. So every case moving forwards is going to apply the same test. It does not matter whether or not the edge of the blade is sharp, it's still going to be considered a blade for the purposes of the Act. So this is an interaction between what you can think of as a civil law system. Now I use the term civil law, but obviously this is an Act of Parliament which sets out various criminal offences, but I explain it in this way so that you understand what I mean. And the common law aspect is the application of the legislation to a given set of facts. Therefore, any case coming before the court in future is going to apply the same principles and the same tests, at least until a higher court overrides that decision and comes out with a new principle or a different principle or a very slightly different take on the given facts. And how all of this comes into practice is, of course, by way of evidence and legal argument. And I make the distinction between the two for a very important reason. When a case comes before the court can only consider what evidence is before it. And this is what I often say is one of the downfalls when my clients have told me that they've failed in a previous attempt and then come to us to help to rectify it. One of the common issues is that they have just simply not provided either enough or indeed any evidence to the court whatsoever. The court can only consider the evidence that is not only filed properly and on time, but also in the correct format, and that it is relevant and fair to be admissible. And using a criminal case by way of example, if the defendant is before the court, let's say for something like drink driving, and has a previous conviction for something like burglary, which is completely different and many years ago, that is not likely to be admissible to the current charge because it's simply not relevant. So assuming the parties have filed any evidence that they wish the court to consider, there will be both evidential and legal arguments, firstly as to why a given set of facts should be found as true by the court, and secondly why the law should be applied in a particular way to those facts. And the more reliance on legislation, the easier the legal argument will be. But that's not to say that some common law decisions are going to be absolutely clear-cut in exactly the same way if the court makes a suitable finding of fact. So the next time you read posts about a common law jurisdiction and civil law and so on, I hope this video will serve as some assistance to understand how these two interact with each other. And as a final word, although I think this goes without saying, a person cannot say that they only stand under one system or another. In other words, a person cannot say that they are only answerable to a common law system and ignore any of the civil law legislation or indeed acts of parliament which set out criminal offences. So I hope this video has served to be useful. Please do give this video a thumbs up if you like the content, and remember, stay humble and subscribe.